and I'm a giants. They try to scare me into thinking I can fight it. They tell me I should never even think of trying. But that's just me, I'm gonna live out in defiance.
Everyone, Big Jason, what's up? So today we're talking about the three biggest mistakes copywriters and business owners who hire them that could destroy their business or worse, and how to fix it. I'm here with Mike Young, my attorney. How's it going, Mike?
I'm doing well, Jason, and yourself?
Excellent. So we've known each other for over 10 years. I think we first met in Dallas at a Dan Kennedy local event. Is that true?
Yeah, probably around 2007.
Yep. And I've used you for contracts, just general legal, online legal advice. I've referred you to a ton of clients. And the one key thing that you're known for is that you don't go to court. You help people stay out of court, right?
That is correct. I hate trials. I hate anything to do with the courtroom. My goal is to make sure the client never goes there, doesn't get sued, and knock on wood, to my knowledge, nobody has at this point. So it's been great.
Awesome. And so we're going to be covering these three biggest mistakes, but also we're going to be answering questions. So just feel free to enter them in the comments and we'll get to them. And why don't you, like, really briefly, just a little bit about your internet attorney experience?
Okay. When I got out of law school, way back when in the Stone Ages, back in 1994, a client said, I want to do something with a cyber mall. It's like, well, what's a cyber mall? So I did the research, and at the time it was pretty much, you would pay if you were a dentist, a lawyer, that type of thing, and you wanted a quote unquote website. It really wasn't one. What it was a single HTML page put on somebody else's website, and you'd pay like $5,000, $10,000 to have that done. And that's how my first legal things were going into what they call the cyber malls. Some of them were called J malls, K malls, whatever. But the long story of it was one website, one web page was your entire presence as a professional online. And that's how I got involved with it. And I've been doing it, internet law, ever since.
Nice. All right. So let's get into it. Let's get into this first mistake.
Okay. The number one mistake I see copywriters make, particularly newbie copywriters, is to misuse swipe files. There is a way, and I will discuss in a little bit, to properly use swipe files. And there's a whole bunch of ways to use it and get into lots of trouble. First of all, if you're grabbing somebody else's copy, chances are, unless they put it in the public domain, and usually they don't, somebody owns the copyright. It may be the copywriter who wrote it. It may be the copywriter's client that paid to own the rights at the time. But somebody owns the rights to it. And just because you can grab a copy offline or at a quote unquote swipe site, or somebody will sell it to you as an info product and have it shipped to you on a USB drive or as a download somewhere, does not mean that you have a legal rights to use it for much of anything, because somebody else owns the copyright to it. So it's intellectual property theft if you go out there and say, I'm going to grab something from Caples or, these John Carlton, Pennsylvania, Halbert, Big Jason, obviously. And grab it and say, well, it looked great, so I'm just going to use it and reuse it for my own client. Well, you can't do that, or your own business. You can't do that. It's intellectual property theft. The copyright ownership is something to take a look at seriously, because what happens if it's properly registered in the United States, at least for willful infringement, you're looking at up to $150,000 per willful infringement. That's every time you infringe, plus attorney's fees and plus court cost that the other side is entitled to collect if you've willfully infringed on their sales copy. So it's not a good idea to do that, because if you get caught and they want to go after you, it can bankrupt you very quickly. A lot of people say, well, that's not my case because I'm doing fair use. Well, most people don't understand what fair use is. In fact, fair use is very fact specific. And one of the biggest carve outs for it is if you're trying to use it for a commercial / business purpose. You can't say, well, I'm just taking parts of it here and using it here, and it really doesn't matter because I'm not using the whole thing. No, that's not how this works. And nor can you throw it through a spinner and create it with a bunch of synonyms and put it out there and say it's fair use either, because it's not. And particularly if you're trying to make money off it, it really gets into the the woods of trying to explain to a judge, hey, I didn't mean willfully to do this to make money. Well, who's going to believe that? So, there's a lot of problems with this for using the concept of fair use. It's like, well, can you give me some examples of fair use? Well, I'll tell you right now. Um, for example, the Associated Press at one time said you can use no more than 4 words of any article we publish. And that includes the headline. Otherwise, you've violated our copyright. We'll let you have up to 4 words in a row that you borrow from one of our articles, and we won't consider it to be infringement. Were they right? Were they
Wow.
wrong? Who knows? But would you want the Associated Press to sue you because you had swiped part of their article online and used it for something? And so it really is very fact intensive as to what you grab, and try to repurpose. But fair use is very hard to be able to use it as a copywriter or as a business owner writing your own sales copy. It's a very hard to use that as a defense, particularly when you're trying to use that copy to make money. So I guess the thing is, how can you legally use a swipe file? Well, the way, if you're experienced with this or if you've been burned before, the proper way to use this is for idea creation. You can take a look at it and see if you can find those pain points. You can look at the bullets there, not swipe and steal, but you can, if you're in a market there and you see a great ad that, targets a same or similar market, you can certainly take a look at it for ideas of how to write your own copy. You just can't swipe it, spin it, whatever, and claim that it's your own because it's not yours. Um, so that's pretty much it as far as swipe files. Are any questions on that?
Um, no, I just know that you're really good at putting the fear of God into people that infringe on copyrights.
I do enjoy writing cease and desist letters. I will give you
Yeah.
that. I don't sue, and I will be referred out if somebody actually has to go sue for infringement. But I do like to send them out there, point out the things of, hey, you're messing up here. You need to stop it right now before things get a lot worse. And here's how it can get a lot worse if you've infringed. So that's something I do enjoy doing because it helps protect my clients. Why wouldn't
Right. Yep.
I?
Yeah. Let's move
And
on to number 2.
Okay, the number 2 is actual ownership. Who does own the copy? And I'll tell you right now, most copywriters don't know. Most clients don't know. Many times it's left silent in whatever agreement there happens to be between them, whether it's a chain of emails, an oral agreement, or even a written contract. That's usually left off the table as to who actually owns the copy. Um, so it is very important to protect this, particularly if you want to be able to recycle the copy or so that you've written for a client. If you want to use it in a similar niche or a different niche, or for a different client in a non-competing area, you need to carve out in this thing who exactly owns what. And my ideal thing, if I'm representing the copywriter, is as a copywriter, you want to own it and license to your client the right to use it under certain circumstances, and then that license ends at a certain point in time. But at all points, you own the copy, and you're able to do many things with it because you are the copyright owner. What if the client says, no, 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 I want to own everything. It's work for hire. I'm paying you as freelancer to come in here and do this as a project. Want to get my money's worth. I want to own it. Well, then fine. The natural reaction to that is, well, then you charge them a premium, 2, 3, 5 times the amount you would otherwise charge them to license it. And many times you'll find a client will become reasonable about this at this point in time and figure
Mm-hmm.
maybe they really don't need ownership. Licensing is enough for them.
Right.
Now, there's another solution here too. Of course, there's many variables here as far as how you can structure this thing in order to put it in your best interest. But one of the things you can do if a client insists upon owning is like, okay, you're going to own it for a certain period of time here, but when you stop using it, it reverts back to me as the copywriter. And that can be put in the agreement as well, so that you're able to turn around and use it again, particularly if somebody is into their marketing campaign with it and doesn't want to use it anymore. Why should you be allowed to use your own work and be able to do that? But if you don't put it in writing, you don't know what you own.
Right. And what would you say is probably, generally speaking, like a good compromise where the business owner feels comfortable and the copywriter feels comfortable?
One that I like to propose is the copywriter owns it. Copywriter licenses it out to use in whatever the market happens to be. And the copywriter agrees for a period of time, for example, as long as the client is actually running the sales copy in advertising, as long as it's going on, the copywriter agrees not to use it in that particular market. For example, if you're marketing, take the My Pillow guy.
Right.
Let's say he's marketing only in the United States and Canada, and he's doing it in English. You know, there's nothing in the UK. There should be nothing to prevent you at any point in time being able to license it to the My Pillow guy if you're writing sales copy for him. But at the same time, for somebody who's doing the same thing, selling pillows made to order in the UK or in Australia, you should be able to write copy for clients over there and be able to recycle some of that content rather than reinvent the wheel. And those are the types of things we like to structure. So it's like, it's not going to hurt you as a client if I, as the copywriter, go use it in a market that isn't competing, where it's not competing, or agree that, for example, I will not use this in the pillow market worldwide until you're done with your marketing. But I have similar markets where the copy here can be used for not competitive purposes, but there's some stuff here that I really know will work, and I'd like to keep this so that I can use it in non-competitive markets. So these are the types of things you like to structure so that both the client is happy because they're getting what they intended to when they hired the copywriter to begin with, which is, obviously to make more sales, um, and do so in such a way that it doesn't infringe upon the copywriter's ability to go out there and earn a living in the process.
Yep. I find that the clients that are more hesitant about all this type of stuff, ownership, are the ones in super competitive markets. Like they're like one of the leaders, and like everybody, everybody is trying to copy them. So it's good to have everything. It's good to, have your interest in writing, but also ease their fears of, you just sharing it with, a brand new client. As you're working with them, you bring on a client in their same niche and they're getting the same stuff.
And one of the things we've seen, from time to time is the copywriter who gets a little greedy, that
Hmm.
says, "Oh, this is awesome. This is working. I'm going to go out there and find a product and source it from China that will compete with it and use the same copy." Well,
Right.
I mean, that's just a disaster waiting to happen. But if you got, that temptation disappears very quickly if you've got in writing what you can and can't do at the beginning, and what you're happy with it. You're not looking down the road 6 months later going, these sales are phenomenal, but boy, how much more money I could make if I sold a competing product using the same
Right.
copy.
Awesome. All right. What's number 3?
Making claims. This is the thing that gets people in trouble in lots and lots of ways. I was reading the other day of there's something called the COVID-19 Act, out there, that making false claims under the COVID-19 Act. They went after this chiropractor up in Missouri that was selling vitamin D supplements and zinc supplements for preventing or treating COVID-19. And I think the FTC was going after him for $43,000 per violation, which could be literally a bottle of pills sold. Um, so, I mean, making claims, the wrong claims, can really put you in a big mess. And in some places, it's criminal. I mean, they don't even bother with you can be
Right.
banned by the FTC, the FDA. FDA, you can be banned from certain things you can do, such as marketing online, marketing offline, or both. But in some instances, this actually becomes criminal because of the claims. Take my magic pill and it cures cancer. That really gets you into not only federal laws, but also things like state laws as far as consumer protection is concerned. And you're looking at world of trouble. And typically on those type of things, it's triple damages, attorneys' fees, and court costs as well. Um, and that's on top of what the feds will do. And what I will tell you right now, and we'll go through this a little bit. What will happen here is, let's say the FTC or the FDA at the federal level in the U.S. decides to nail you for making the wrong claims. You have state attorney generals out there that want to protect the consumer, particularly in an election cycle, and they see what's going on for a settlement there. They take their own state law that's similar to the federal law and then decide to sue on the same grounds, knowing full well that you're going to settle with the feds. They might as well pile in and get some good press in the process and take some money too for their state.
Yikes.
Um, so, we're talking about making claims. The biggest ones, obviously, are in the consumer markets. If you can structure these deals B2B, it's ideal because it knocks out a lot of the risk as far as claim making is concerned. If it's a B2B offer, I know there's some gray areas there, but you can work with the client as far as dear fellow business owner, not, dear individual who would like to earn $1 million per week. And, that's, dear business owner, you start carving things like that. As you work in your existing business, wouldn't you like to grow it? Is a lot easier than saying, you know, would you like to earn money? And we know you may be unemployed now, a newbie or no business experience, buy our product and you can make so much. That's, one throws you into the consumer laws briar patch and one does not. Um, Now, the things you do look at, obviously, with the health and monetary things is, health is, um, a biggie as far as making any types of claims. And COVID has been the most recent, but cancer has been the long time standing one. Do not imply in any way, shape, or form that your product, particularly nutritional supplement or exercise or whatever, is going to cure cancer. Monetary claims, once again, how I earned, $10,000 a week while sitting in my underwear, blogging. These are the types of things you really do not want to do if you're targeting individuals. It gets you into lots and lots of issues. And let me tell you why. Let's say, for example, you have a product that allows somebody to earn $10,000 a month. In fact, you've got 3 clients who came in and gave you glowing testimonials and even showed you some of their earnings, their PayPal records, and the rest of it showing they were actually earning the $10,000. Everybody else who bought, the FTC and other regulatory agencies are going to assume made no money or lost money using your product. So you can't, rely upon selective testimonials, when you don't have scientific studies to back up these particular claims. Speaking of which, if we go into, health issues and whatnot, weight loss, somebody lost, 10 pounds, taking such and such supplements or, protein shakes, whatever you want it to be, a keto, your particular keto, type of diet, whatever it happens to be, those types of claims as well, if you do not have scientific studies to back them up, and you're going to want something reputable, preferably peer reviewed, you do not want to make those claims. Now, can you use some of these things as far as anecdotal? Absolutely. You can show the before and after effects of some of these things without stating these claims specifically, and you can let the prospective customer make the mental leap themselves. If you've got pictures of people who are 450 pounds, a bunch of them who used your product, and then you've got them glowing and happy later that did, and it looks like they lost 200 pounds. You don't say lose 200 pounds, but you can certainly show the after effects of where they are now without letting, let them make the prospect make the mental leap. Ideally, you will have something such as a case study to back it up, showing all the key material facts of what was done in addition to using your product. For example, if they worked out 2 hours a day, if they did a 1,200 calorie diet a day. These are the key facts a prospective purchaser would want to know, in addition to the fact that they also purchased your product, so that the purchaser can make an informed decision whether or not to buy. Any questions?
Yes. What would you say, generally speaking, from a copywriter's perspective? Say, your contract's good and everything. You start the project, and say, like me, the first thing I do for my email revenue clients is I ask for access to the support desk or wherever email replies go. And let's just say I'm just like, oh my gosh, the refund rate is like 40%, and like I'm seeing tons and tons of hate mail, and people are upset because they're not delivering what they like. A huge majority of refunders thought they were going to get, and they're saying, I didn't get this, give me my money back. What would you, generally speaking, can you say anything or not really?
Well, one of the things you want to do in the contract is protect yourself as far as best efforts with the client, with fulfillment and the rest of it, where the client is actually in breach if they're not fulfilling on their end. That way, to the extent that there is an issue, one, they're indemnifying you as far as any types of claims that are being made as part of these angry refunds, that you're, to the extent that somebody's trying to come after you because of what was said as opposed to what was delivered, and or not delivered in this case, for example, if it's a fulfillment issue. And two, the client is liable to you because they've actually breached the contract. Now, there's certain ways you structure that. For example, you could have a liquidated damages provision on there, as we don't know what the damages will be if you don't perform, client. But if you do decide to breach, by not fulfilling,
Mhm.
then we're mutually agreeing that the damages are X amount. And that's what you're going to pay over per the contract because you screwed up, client.
Got it.
Particularly, and this is particularly important when, part of your compensation is based upon the back end. I mean, or if all of it is based on the back end, which I hope is not the case with, I know some newbie contractors will do that right on spec, and I'll get a percentage of such and such. But obviously, you want something up front, ideally, and assume that it may be gravy on the back end because things do happen. Um, but obviously, if you're legally entitled to it, you should be able to collect it. And if they don't deliver, then you should be compensated because they failed to deliver to the customers.
Got it. Yeah, I see a lot of, especially in the keto space, it's huge right now, and people are just like regurgitating custom meal plans, but it's not really custom.
Yeah.
I've had quite a few clients that that's the biggest complaint refunders have is that, like, yeah, I changed my options and it doesn't change anything. You lied to me.
And like I said, I mean, the best way to do it is by written agreement as far as protecting yourself as a copywriter.
Right.
Now, understand, the other things you're going to want to have too: liability insurance, ideally. And if you're contracting as a freelancer, it's your LLC or your corporation that's doing the contracting versus you as an individual, so that you're avoiding many of the personal liability issues. So if there is something bad, they're not going after your personal assets.
Right. And you cover liability insurance in your new book, right?
Yeah, I do cover that. Now, I will say there are certain situations where it will not protect. Like I mentioned before, the FTC going after that chiropractor guy. I don't want to say that it was foolish, but let's just put it this way: many of the things he did was as an individual to make the claims, as opposed to doing on behalf of the business. And they nailed him as an individual defendant too, in addition to his business entity. So I mean, he went under the name Wellness Warrior, I think was the name of the company, but there was a lot of things being said by him individually, and so the FTC is like, we're going after both. So I mean, obviously with most copywriters, that's not an issue. But if you're doing copywriting for your own products and services and selling, it better be darn clear that whatever you're saying as far as claims are concerned from a protection standpoint is being made on behalf of the company, not by you as an individual, particularly if you have some type of professional credentials. For example, in this case, it was the chiropractor, a dentist, a lawyer, doctor, whatever happens to be. That line gets graded a little bit. And if you have written sales copy, for example, that signature's down on the bottom and your name is Bob, it better be Bob, your title with your company and the name of your company beneath it, to make it clear that you're acting on behalf of your limited liability company, your corporation.
Great. And guys, the link is on the screen. It's not an affiliate link. It's just a short link to make it easier for you. It's available on Amazon and Kindle and paperback. bemclick.com/BYC. I'm going to go back to this screen and show you. I've got the book myself. I actually got a review copy, advanced review copy, right, Mike? But I went ahead and bought it anyways. So I wanted to support. Sure, wanted to support you, and it's really what I love about it. It's not you don't take 25 pages to get across 3 valid points on each chapter. It's really succinct and just hard hitting, and this is what you need to know, and then you move on to the next one.
Yeah, I wrote it intended, first of all, as a quick read, so you can go through in plain English and understand these are the big pitfalls. Please try to avoid them, and here's what you can do to protect yourself. And then it's a quick reference book. So I mean, the chapters are clearly learned. I'm not using intriguing, trying to capture your attention titles for every chapter, but that you don't understand what it actually is. The chapters are clearly laid out. So if you have a question that comes up, you can look at the table of content and say, let's take a look and see what the answer is.
Awesome. I had a question. I saw actually some Black Friday sales, and I had a question. So at checkout, so you have a Black Friday sale. I'm not going to say the name or even the niche, but let's just say they have a really low Black Friday deal. They go to checkout and they have the bump offer pre-selected. I will say that it is an older demographic, so seniors. So like literally the price jumped with the bump pre-selected by $60. It was pre-selected. What would you say to that?
I would say that's asking for trouble, particularly when you're talking about a target market like that. If it's a business owner, sometimes you can get away with something like that. If like, dear fellow business owner, here's something, software that helps you with your accounting for your business. You might get away with it with that because courts really don't want to get in these type of disputes. And their view is, everybody's sophisticated business owners and they should know better. When you're talking about consumers, particularly seniors, little children, unemployed, you know, single parents at home. These are the types of people that you really do not, because one is it makes great headlines. The media loves this when politicians go after it. And two, it's just a slam dunk because they can walk into a judge and the judge is like, no. And it reminds me a lot of the people who have the pre-checked box for it. It used to be, the old thing of during checkout of, oh, and you get a free trial as a bonus of our whatever it is. And hidden down the fine print was after 14 days, we're going to start charging you for a continuity program that was 70, 80, $100 per month. The person thought they were buying a bottle of pills or, a special report, but as a quote unquote bonus, they were getting a trial look at such and such, and it was already pre-checked. It was basically forced them in the continuity as part of the checkout process, and probably 99 out of 100 people who went through and read didn't understand what they actually were committing to.
Interesting. Um, I can almost guarantee that this company heard of this strategy at a mastermind. And we can probably assume that the person said, oh, yeah, I haven't got caught. I've been doing it for years. It works amazing. And then the business owner's like, really? Yeah, I'm going to try that. Not the
Yeah,
smartest.
I mean, you're doing fine until you're not, and when you get
Right.
caught, it's the downside risk. I mean, one of the things that I like to talk about is it doesn't matter how well your sales copy converts if the government decides to come after you, or you get a greedy shark that litigates class actions that decides that everybody who ever bought from you is now a victim, and they're going to file a class action lawsuit and make your life hell, for the next 3 years. And even if you have insurance, by the time it's over with, you're sorry you ever got into the business to begin with, because well, I don't care if it converted. I don't care how well it converted. There's no payoff that was worth that. I mean, the classic one is the uh, Mr. Trudeau. I mean, I think you're familiar with
Right.
him. You
Yep.
know, hundreds of millions of dollars, but how many times in and out, you know, criminally being gone after, sued numerous times. I mean, you couldn't sleep well at night, not knowing when the hammer was going to fall, when you were going to be served with a warrant, because of all the different times you crossed the line and the government went after you because you were on the radar. It only took once to be on the radar.
Right. There's a big thing going on right now with email warm up services. Have you heard of that?
Yeah. I mean,
So,
I'm, please go
so
ahead.
yeah, so GMass, which in of itself it's a decent software that allows you to email a list of cold leads from your Gmail account. There's debate on whether that's against their terms of service or not, but the definitely against the terms of service that they have of a warm up feature. So basically, all GMass customers that opt into the service, they email each other back and forth, remove from spam, move to primary, stuff like that to fake engagement. And then other companies, they do basically the same thing. And I have a good friend that's been deliverability for over 21 years, had a deliverability for one of the biggest autoresponder services ever. And he had already told me, yeah, I would never do this for a client. It's against their terms of service. You could get an email death sentence. And Gmail just now sent a notice to GMass that, you need to stop this as of, I think, February, or they're going to, shut them down.
And I don't think that, people still understand unsolicited commercial email is still spam. I don't care whether you got somebody's business card, whether you and your buddies are swapping lists, it doesn't matter. Unsolicited is unsolicited. Not only is it unsolicited, but it's unsolicited if it's beyond the scope of what the person opted in to receive any types of emails to begin with. So if you've got a site that, for example, is about making money, and somebody opts into a list there, and you suddenly go out with a nutritional supplement, you can't go to the nutritional supplement prospects and start on your other and start over there. There's no consent for it. What the opt-in was for the one didn't give a consent to go over and start selling something else to them. So I don't think people really understand that. And it's like, well, it doesn't matter. Everybody spams. Not really. I mean, um, I can give you two situations here of two attorneys. One I know went to law school in California just so that he could sue people under California's spam law. And he makes a very good living doing so. He signs up for a list and then he sues them himself. Or he has other people that sign up for the list and then he sues them under it. It really doesn't matter, but long story is that was his sole purpose for going to law school, was to sue people under California's spam law because he hates spammers. I also know somebody who became a lawyer. She became one because her brother at the time in the early 2000s was known as the spam king of the world. And I kid you not, he would probably at the time was spamming more people on the planet than anybody. And she was helping trying to protect her sibling from basically going to jail and losing everything because of what had gone on. Now everybody's like, well, no, that it doesn't happen to everybody. And I will agree it didn't. But many of these people you see out there, the so-called gurus who push it the most, they did the bulk of their spamming before most of the spam laws were in place. Then they got cued after the fact once they became quote unquote guru status, and there was a lot of leeway that allowed them to do things from a bending standpoint. And even then, many of them get nailed behind the scenes, and you'll never
Mm-hmm.
know about it. But
Okay.
I can tell you right now of at least a dozen people that are so-called marketing gurus online that spam the heck out of the planet before the spam laws were passed. And now they sit back with their graying hair and like, oh, look at me, you can do this too. It's like, no, nobody could do what you do right now because they would get in trouble.
Yeah. And so, yeah, I responded to the GMAS actually posted in their private Facebook group, like, is the email warming system going downhill? And I talked to a bunch of people that actually run these services, and they're, oh, no, that notice mentioned the API. We don't use the API. We use bots that pull up the Chrome browser and go to Gmail. And our artificial intelligence is human-like behavior. And I told him, I said, look, I'm telling you, my buddy, 21 years deliverability, head of deliverability, formerly of one of the largest providers in the world, he told me it doesn't matter what before this happened, or Gmail laid the smackdown, he told me, as a matter of fact, regardless of API, Gmail, Hotmail, Microsoft, Yahoo, AOL, everybody personally told him and or other people in his company that it was against their terms of service way before this. So it doesn't really matter. And then I was talking to him, I said, hey, look, GMAS finally got smacked. And he goes, and I asked him about that. I said, what about these email warming companies that say, oh, we don't use the API, that doesn't apply to us? And he's like, well, yeah, like I said, I already told you that it is against the terms of service regardless of API. And then check out this lawsuit from Microsoft in 2010. And it literally says they sued this guy because he created tons of fake accounts, bots that pretended to be real people that would move people out of spam. It's like eerily similar. And then people think that they can still do this.
I mean, people forget the concept of Google slap. There's a reason why that term exists, and it's not, it's just not for SEO, keyword cram stuffing articles and stuff online. A Google slap is a Google slap, including on Gmail. And obviously Microsoft as well. These companies play for keeps, and do you really want to go up against them? How are for example, the legal teams for these companies are just phenomenal. I mean, they have some of the largest ones
Right.
of outside counsel, not kind of their in-house counsel. You're not going to win. First of all, they wrote the rules. The rules are stacked against you to begin with, and you violate the rules, and then they have hordes of lawyers they can come after you with if they choose to do so.
Right. And just generally speaking, is it is it crazy to say, like, if whether it's the FTC, state attorney general, or one of these big companies, like, even if you're found not guilty, you're still you could be up in the hole like 250K. Is that unreasonable to say, just
Oh,
in defending
easily.
yourself?
Easily. And not only that, but a lot of times it's, by the way, we want all of your assets. If you make yourself a big enough pain to these companies or to the state attorney general or to the FTC or the FDA, they're like, you're out of business, clown. Not only are you out of business, but we're refunding whatever monies you got from these people. And on top of that, whatever assets you got here, we want, give it to us and maybe we'll go away.
Right.
I mean, and people's like, well, this is unfair. Well, it's the golden rule. The person who has the most gold rules. I mean,
Yep.
and you don't want to be the attractive target for somebody that you've ticked off in that has significantly more assets than you do.
Definitely. All right. So this has been amazing. Appreciate your time. Here's your book again, Bulletproof Your Copywriting, 12 Sales Copy Legal Dangers and How to Avoid Them. The link is bemclick.com/BYC, Bulletproof Your Copywriting. And lastly, you want to talk really quick about Legal Form Generator, which I've used for years.
Yeah, that was set up. It was set up way back, I guess, around 2008, and it keeps getting updated. I think the last update was in October. And what it is it's website legal forms for basic policies, privacy policies, terms and conditions of use, refunds, returns policies for people who can afford to get custom ones done by an attorney like me. I do prepare these as a template that are used. The software generates them. It takes about 15 minutes or less to get them generated. And so this is basically an affordable solution for people, particularly small business owners starting out with a website online, or everyone's trying to test a site before actually going out and getting the custom stuff done.
Right. And the link is bemclick.com/LFG. That is an affiliate link. I use the service, have used it. And the cool option, I think, Mike, is that you can choose to either have a dynamic link to your custom or your templated terms of service, privacy policy, and all that through your service, and it'll automatically update when you update it, right?
Well, what'll happen is there'll be an update released, and you'll get an email that said, if you want the update, here's what the changes are. Just log in and click the update button, and that's it. So we don't do it for you because don't the company, the software company that this is licensed through, doesn't want to be accused of practicing law without a license. It's basically allows you to have the choices to do it yourself. So basically, you get an email that says, hey, look, in October, for example, we changed the following things in the privacy policy based upon new updates to privacy laws. Now you can go in and log in. If you don't want to, you don't have to. But if you want to, just go in, log in, click the button, and it automatically updates it. And that's it. You don't have to go load something that new to your website or anything else. It's automatically done for you at that point.
That's awesome. Yeah. So if you link out to your service, they just have to log in, click the update button, and Shazam, it's updated. They don't have to manually go in and write it in and all that.
That's correct.
Awesome. And but also, if you prefer, you can actually put the copy on one of your own pages, right?
Yep. Some do, some don't. It's a personal choice.
Awesome. Well, guys, appreciate it. If you have any follow-up questions, fire away and I'll give them to Mike. Mike, I appreciate your time and I hope you have a happy Thanksgiving with you and your family.
You too, Jason, and look forward to answering any questions anybody might have. One final note before we go. Don't be scared off as far as the book's concerned. Many of my clients that have used the information you're going to find in here have actually found that things work better as far as conversions are concerned, because it actually adds a bit more credibility to your sales copy by making some tweaks based upon what you learn in this book.
Awesome. All right. Take care, Mike.
All right. You too. Bye.
See you, everybody.